You may start off with an initial payment of $500 and add to it whenever you wish. The money is placed in a bank account in your name in trust for Gleason's Funeral Home. We use the pre-planned funeral trust as the funeral trust administrator. With pre-planned families, pre-need funds are 100% government backed and audited quarterly to ensure compliance. They are the gold standard. Their business rating is A+. Your money is FDIC insured, and the funeral home can't touch the money until the death occurs. This is New York state law, and it's the best protection for the consumer in the country. Also, you are allowed to transfer your pre-planned from one funeral home to another. For example, we received quite a few transfers from St. Andrews and St. Mel's parishioners when Fredericks and Quinn Fogarty were sold to a national chain. The national chains, they don't really want you to know who owns the funeral home. And even in St. Andrews Bulletin today, they still have Fred Passarella owner, and he hasn't owned the place in 10 years because the Service Corporation International owns it. The pre-plan account collects interest. The net consumer yield for last month, March 2023, was 1.76%. If you are not receiving Medicaid, you can get your money back with interest at any time. The money is placed in a revocable account if you are not receiving Medicaid benefits. If you are receiving Medicaid benefits, the money has to be placed in an irrevocable account, which means whatever money is put in this account has to be spent on your funeral. If any money is left over in this account, it'll be returned to the Social Service Department of the county that you live in. There is no limit to how much money can be paid for a funeral if you're receiving Medicaid benefits. It is perfectly legal, exempt from the nursing home and the government. A question we've been asked sometimes is, what happens if Gleason's goes out of business? The question brings to mind a woman named May. I had just received my funeral director's license in 1979 when a friend of my family came up to me after church services and said she wanted to make pre-arrangements, which she did and paid for everything. She was 75 years old. Every year she would call me to update a file. One year she added him, another year a different clergy person. In 2005, 26 years later, at the age of 101, she called me to ask what happens if something happens to me, John Golden. I started to laugh while saying at the rate you're going, that's a possibility. But don't worry, your funeral is FDIC insured and transferable to any New York State funeral home. 5 years later, at the age of 106, she passed away, and we took care of her funeral arrangements and honored all her requests. We take care of cremations, burials, and entombments. If you decide on cremation, the Catholic Church now allows it. You can have a wake, a mass, and then cremate. Cremains are a perpetual responsibility and should eventually be buried or placed in a niche or a grave. We recommend if you make your funeral arrangements in advance, there is a new agent form you should fill out to ensure your wishes be followed. This form is just for your funeral arrangements only. The person you name as your agent is in charge of your funeral arrangements only. You should print on the agent form if you want a mass, or especially if you want to be cremated. If you don't have surviving relatives, a friend, neighbor, priest, rabbi, or pastor can be your agent to make funeral arrangements. This is especially important now that New York State is a majority rule state, which means a majority of your children, if they are your next of kin, must agree to your cremation or funeral arrangement. The designation of an agent eliminates this problem because the agent you choose makes all the decisions when the time comes. All our funeral directors at Gleason's Funeral Home have years of experience and training are available 7 days a week. Also, there's no charge to make pre-arrangements. Honorably discharged veterans are entitled to a grave for themselves and spouse at a national veteran cemetery. It is very important to have a copy of your honorable discharge. Also, we will arrange to have military honors for the veteran. If anybody has any questions, feel free to ask me or any one of our directors who are here. At this time, I would like to introduce Ann-Margaret Carrozza, a nationwide respected expert elder care estate planning attorney. We are fortunate to have her here today.
Good morning, everyone. It's a great pleasure for me to be here with all of you because last night I had a nightmare that I overslept and I got here an hour late. There were like 2 people left here. John was mad at me and our participants on Zoom had all given up. So when I woke up and it was only a dream, I was thrilled. So thank you to all of you who braved it out in the inclement weather. And hello to all of you who were on Zoom. For the Zoom participants, you don't have the handout. So if you want me to mail one to you, just give the office a call Monday morning and we'll mail out a packet. I also have a lot of the information on the website, and that is myelderlawadottorney.com. Okay, so let's jump in and ask, what is the most common document that people have when we talk about estate planning? A will. And we should all have a will. But the question is, what does a will do and what does a will not do? So the will, at its essence, determines who gets my stuff when I die, right? I list all of the names of the people who are going to get my stuff when I die. But what happens if between now and that day, hopefully many years from now, what happens if I have the bad luck to be sued, to go through a financially ruinous divorce, or to have a long-term care issue? So for those types of potential liabilities out there, we want to think about doing something in addition to a will. And what is that? A trust. We really want to do a trust. And I think, you know, the question isn't whether or not I need a trust. The question is what type of trust. For people who don't own real estate or don't own a co-op, you can avoid probate by simply naming beneficiaries on all of your various accounts. So we want to avoid our beneficiaries having to go through the probate of a will, because that's a court process. And if there's any complexity within the family, so complexity is a euphemism for, you know, if we have dysfunction and I haven't talked to my brother-in-law since Thanksgiving of '98, and we have rifts and fault lines, we need to do some special planning, and that happens within the form of a trust. What are the 2 basic trusts that you've all heard of? Revocable and irrevocable. Between those 2 polar extremes are dozens of other possibilities. And I think the overwhelming majority of us need to be between those polar extremes. So starting with a revocable trust. A revocable trust is very appealing psychologically. You can buy them on QVC. Susie Orman will sell you a kit And the appeal with the revocable trust is that no one is the boss of me. I am my own trustee. I can put the things in the trust. I can take the things back out of the trust. Okay, great. But what's it doing for you? Because if you can access that asset whenever you want, you can put your hand in the cookie jar whenever you want, so can the nursing home, right? If I have the bad luck to need extended care beyond the 100 days that Medicare and the supplement cover after a 3-day hospitalization, if I need care longer than that, they're going to be looking toward my assets, and assets that are in a revocable trust are 100% available to long-term care claims. So we do want to think about a little bit of a stronger trust. The good news, though, is that it does not have to be a totally irrevocable trust. A totally irrevocable trust is as lousy as it sounds. I can't change anything. I have to name another person. So John is my trustee. I put my kids down, one of whom is over there in the Yankees hat. I put my kids down as beneficiaries, but I can't change anything. If a child develops a problem later in life, a substance abuse issue, a psychiatric issue, their own long-term illnesses, I'm powerless to make any changes. So any of you who think about going down the planning route with a trust, you want to make sure that you're retaining a lot of powers. You want to retain the ability to change who the trustee is. If John moves away or if we have a falling out, I want to be able to change the trustee. I name my 3 hypothetical children as the beneficiaries. I want to retain the ability to make changes. Why? Because if I name the 3 kids as beneficiaries, period, do you know what that means? That means my assets in the trust are vulnerable to their liabilities out there in this world. Because if I did not retain the ability to change the beneficiaries, their interests are vested or they're frozen. Yeah, the creditors will have to wait till I die to get it, but they will get it. They'll have a charging lien on those assets. So at a bare minimum, I want to retain the ability to change the beneficiaries. Because what would happen if, God forbid, my daughter predeceases me? I don't want her will taking effect, because who does her will leave everything to? Her husband. And that's fine with her stuff, but this is my stuff, and I want my stuff to go to the grandchildren. But if I did not retain that ability to make those changes, I would be out of luck. So we want to retain the ability to change the trustee, retain the ability to change the beneficiaries. And what do we want to put into this trust? You don't have to put everything in the trust, because those of you with retirement accounts, do we have any retired teachers in the room? If you have a big, beautiful TDA, that doesn't have to go in the trust, because that is already invisible under New York state law for long-term care purposes. If you have an IRA, a 401k, a SEP, a 403b, a 457, whatever your retirement account is, it is invisible to long-term care claims. So if any of you are taking notes, the one thing you don't ever want to do is change the ownership of your retirement account into a trust. No reason to do that. You already have beneficiaries on it. So it's going to avoid probate one day. And the principle of it is invisible if we have the bad luck to have a long-term illness. So we're good to go on our retirement accounts with one exception. If my beneficiary, which is typically going to be a spouse in the primary position, if my beneficiary has long-term care issues, he should not be the beneficiary anymore, right? So if my husband has Alzheimer's, if he has Parkinson's, whatever his possible long-term problem is, he shouldn't be my primary beneficiary, because if I die before he does, everything falls into his lap and a nursing facility can grab it. I don't want to disinherit him though, so I will name this trust as the primary beneficiary so that the account pays into the trust and my trustee can use the money for his benefit without subjecting it to long-term care claims. Anyone have any questions on this trust? Yes.
So what if you put property in it, in the trust, and you decide to sell that?
So the question is, what if you have property and that's really the only thing that we want to put in the trust initially, because you will not feel the difference at all. And I'll keep coming back to this mantra, if the trust is properly drafted. If the trust is properly drafted, it's going to say that Ann-Margaret Carrozza can live in the property, without any conditions for the rest of her life. If we also put investment property in it, it says that I get all of the rental income. You're not going to feel the difference at all with real estate. But we want to make sure within the trust that the property can be sold if I want to sell it, and that the property can't be sold if I don't want to sell it. So what is the difference then, you may be asking? If the trust gives me so much power, what's the difference between me owning the house and this asset protection trust owning the house? There's one difference. If I want to sell, my trustee can't sell without me. But if I want to sell, we will need two signatures. We'll need my signature and the trustee's signature. That is what gives the assets in the trust their protection, because if I do the trust, I put my real estate in the trust, I can have 3 pieces of real estate in the trust. There's no limit to what I can put into this trust. As long as we wait 5 years, that's the federal look back or baking period. After 5 years, do any of you remember it used to be 3 years? Now it's 5. There's a bill in Congress that would make it 7, but anyone who does their trust under the current regime is grandfathered into the 5-year. So let's say 7 years down the road, I want to sell it. We need my signature and my trustees. Putting that little requirement or that little fly in the ointment enables me to say, I can't get at it acting alone. And that's true. As a legal matter, that is true, that I acting alone can't pull the stuff out and sell it or put it back in my name if I get mad at the whole world. With my trustee, though, together we have the magic power to sell it, to put it back in my name, to do whatever we want to do. So playing devil's advocate, if we have a falling out and or his wife doesn't think that I should sell it, on and on and on, I simply thank my trustee for their service to date and inform him or her, you're no longer a trustee. I'm going to put someone else in there. I could put my accountant in there. I could put my real estate attorney. I could put the neighbor down the block in there for 5 minutes. simply to get that second signature. So think of the trustee as a placeholder. Now, why is putting my home into the trust better than just putting the house into the kids' names? And, you know, I see this all the time, that people, you know, the concept of a trust gives them a headache, and they say they just want to keep things simple. And their friend's nephew is in law school and he can do a new deed. And we take my house and put it into the names of my 3 kids. Even if my 3 kids are lovely, there will be tax problems. I bought the house in 1978 for $50,000, and it's now worth $950,000. If I make a gift or a transfer of that property during my life, the kids are going to forever after have mom and dad's purchase price as the floor to later measure capital gains. So even if they're nice and they let me live out my days there, when they go to sell it, the thing could be worth $1.2 million, and they have to pay capital gains on the difference. Number one. Number two, if any of my kids have college age children, the ownership of part of the house would have to be disclosed on the financial aid application. So it's just a disaster. If all of that wasn't bad enough, mom loses the Star property tax exemption. Do we have any veterans here? Oh, thank you for your service. By transferring the property directly, we would lose our partial veterans exemption. So doing nothing is better than just transferring the house into the kids' names. Any questions so far? Yes.
You had mentioned with the irreversible, irrevocable, right, trust, really can't change anything. So why would that be recommended?
Oh, so what a brilliant question. So we have a revocable trust. You know, I guess that's better than nothing because you'd avoid probate. Okay. And then we have a totally irrevocable trust. So I'm practicing 27 years, and I've never recommended that anyone do a totally irrevocable trust. Why are they out there? You know why? I believe that some attorneys don't know exactly where they need to stop on that continuum. And I tell the story in my book about an attorney that I'm still social friends with him. You know, you'll air kiss each other at some event. And he's a personal injury attorney. And about 15 years ago, he told me he was doing a trust for a client and would I take a look at it? Okay, I thought it was odd that he was doing a trust, but I take the document home, frustrated school teacher that I am, and I'm on the couch marking it up. And it was like the legal equivalent of a horror movie. He is referring to provisions of the Internal Revenue Code that had been repealed decades earlier. And it was so clear what was going on here. He got this document from the files of some retired or deceased attorney. He had his secretary swap out the names. And now I'm sitting here with like a really, really terrible document. And now I'm in this like Dear Abby quandary. I didn't know what the heck to tell him. So Monday morning, I called him and I said to really evaluate the trust, I need some more information about your client. Now, should he have given me any information about the client? No. He asked for my fax number, and moments later, I had the client's social security number, you know, deed to the house before it was a public record, financial statements. Okay, So I basically redo the whole trust. And let me tell you, this was not going to be a perfect fit because I did not talk to the client. I did not, find out, are you concerned about your daughter-in-law spending money like a drunken sailor? Is your daughter on her third marriage and you have to keep, paying attorney's fees for the divorces? Many very personal questions have to be asked in the course of this process. But anyway, I give him something much better than he had. But I maybe it was a male-female dynamic. When he asked me, so how was the trust? I said, I made a few changes. Now, there was nothing remaining of the old trust. And he said, well, good to know I was basically on the right track. Okay, but the real scary part about this is to this day, he has a shingle elder law. And I think he is peddling that one crummy trust that I did for him 15 years ago. And it's like a broken clock, it may or may not be right for a given client. So why would someone do a purely irrevocable trust? They shouldn't. They should never do it. And if you embark upon this process, you need to be a partner in the mix because the people you're dealing with. I don't know the people you're dealing with, but I need to know a little bit about them in order to prevent a feud on the other end. Did you loan money to a daughter for a wedding or a down payment on a house? Okay, most people have. Do you want that to be an advance against her interest in the ultimate estate? No right or wrong answer, but you need to step up and make it clear what you wanted. Because on the other side of the rainbow, she's going to be saying, no, mom made a gift to me. It had nothing about the estate. And now her brothers are going to be saying, what are you talking about? That should come out of your 1/3 of the estate. So that's an example of, what we need to do in this process. We need to sit back and think about what could the possible problems out there be. If I have a child in a shaky marriage or a shaky relationship, I want to say, I leave everything 1, 2, 3, even Steven, as their separate property, not to be commingled with a spouse or partner. This way, they can blame old dead mom and they don't have to have a backbone, but the assets are protected legally for the ultimate benefit of my grandchildren. So we put the real estate in this trust. The retirement accounts are already good to go, which leaves the everything else, right? Your non-retirement investments, your CDs, money market, checking account. What should we do with all of that? And for most people, the answer is nothing. Just leave that alone, but let's make sure that we have a power of attorney. With a good power of attorney, my agent can very quickly transfer those accounts into the trust in the future if I get sick. Because as I said with the asset protection trust, with the real estate in there, I promise you will not feel the difference at all. If I put my last $5 in there, yeah, I'm going to feel the difference. I don't want to have to go to my trustee if I want money to get my hair done or go out to dinner. So, don't let the perfect be the enemy of the good and leave yourself, with your liquid assets. In years to come, we talk about maybe gradually adding things into the trust. Maybe someone who does the trust before they start taking their RMDs in the retirement accounts, maybe for them, once you start taking the RMDs, that's money you've lived happily without your whole life. Maybe you start putting that into the trust. So like a balanced approach. And if we have a husband and wife, they two have to do power of attorney over each other. If I have a joint CD with my husband and he has the bad luck to have a stroke or a dementia-related illness, and I go to the bank to break that CD early, if I don't have his power of attorney, they're not going to let me do it. But if I do have power of attorney, I'm going to break the CD. We don't care about losing $100 in interest because I need to get that into my name quickly so that we can possibly apply for a program for him in a nursing facility. Okay, there was someone in the back. Yeah.
Yeah, so you mentioned RMC. So is there a way, like when you get to the point that you have to start taking the RMCs, is there a way that you can put it into the trust without giving access?
No, so the question is, can we get out of income taxes on the RMDs? No, no, and no. Yeah. So
No estate strategy.
no, no, and no.
You mentioned that investment properties. Can investment properties be put into like a self-directed IRA? Could that be a way instead of putting it in?
Yeah, so you can put investment properties into a self-directed IRA. It's complicated. There are a lot of restrictions with it, but I have clients that do that.
And would that be advantageous?
That is, you know, a 40-minute conversation with your CPA as to whether that makes sense for you. But yes, it can be done. Yes.
The RMD, if you donate some of the money, you don't pay tax on it.
Right, but you don't get it either, right?
That's
So
true. That's true.
any charitable donation is, you know, going to save you from taxes. And, you know, I think that's a good segue because, you know, one of the other things that we talk about is protecting assets from taxes. So we just talked about property taxes. When the property comes out of the trust to my 3 beneficiaries down the road, do they have to pay capital gains? No, no. And this is the single biggest difference between doing something dumb, like putting my house in my kids' names, and putting my house into an asset protection trust. Because when it comes out, whether it's the house I originally put in there, or a replacement residence, or a brokerage account that we bought from the sale proceeds of the house, any capital gain in there is eliminated upon the death of the grantor if the trust is properly drafted. Okay, so that's capital gain. What about estate taxes? Now, at this point, someone's going to say, well, that doesn't apply to me because the federal exemption is now 12.8 million and the New York state exemption is 6.8 million. But you should not permanently tune out of this discussion because my former colleagues in Albany are talking about lowering the New York state exemption as the magic fairy dust of federal stimulus money dries up and they need to come up with some real ways to balance a very difficult budget. So one of the things that we can do to save on estate taxes is to build in language into the documents. If you have a favored charity, now in a vacuum, I think 10 out of 10 people would want to see something going to a charity, or for St. Andrew's parishioners, you'd want to see something going to St. Andrew's. But what is the number one thing that makes me reluctant to do a charitable beneficiary within my estate? It's that I feel like my kids need it more. So we say, yeah, if I had a lot more money, I'd be making these charitable donations. But what if you put language into your estate plan that said any dollar otherwise payable in federal or state estate taxes, I give to St. Andrew Avellino? Okay, that's money your kids weren't going to see anyway, because it was going to be payable in taxes. So why not, put a little of our personal imprint on the plan and say, rather than the folks in Albany deciding what to do with that dollar, that we leave it to the charitable organization of our choice. So that's a way to benefit the causes that you believe in without taking from your natural beneficiaries. Any question? Yeah, sir.
And let me make sure I understand you correctly. If you put your house in a trust, okay, it protects you from the attack with the last long-term care providers, correct? But when you sell that house, you're subject to, when the kids sell it and it pass, that they're subject to the capital gains tax.
No, just the opposite.
Put it in the trust, they get it at the step up in basis, and are not subject to the tax, but they're still subject to the attack by the.
Just the opposite. When the house goes, the investment property, whatever it is, when it goes from the trust to the beneficiaries, they get the step up in basis. Yeah.
Even if it's in the trust.
Yeah, they get it because it's in the trust, and it has to pass at death. That's the Internal Revenue Code requirement. Assets passing at death go to the new owner with an elevated cost basis. Yes. However, and maybe you heard something out there that would not be incorrect. Don't take notes on this. If you ill-advisedly put your appreciated asset into a purely irrevocable trust, it would go in with carryover basis. But if the trust says that mom is able to live there her whole life and she can change the locks and not let the kids in, now I've retained so much control that we get the step up in basis. Yeah, so I think maybe you heard something that was not wrong, but it was a wrong planning thing. Yeah.
For small private families, it's come to you and say, well, I would like the beneficiary to also be a trustee. Is it allowable, advisable, and your thoughts?
I'm glad you asked that question, because typically, can the trustee also be a beneficiary? In the 1980s, it could not be. We had something, don't take notes, it's not the law anymore. It was called merger doctrine. So a trust disintegrated if you had two hats. But the legislature reasoned that the people I love the most, that I want to have my stuff, are also the people I trust the most. So I don't want to have a stranger as my trustee. I want to have my loved ones as a trustee. So 95% of the time, your trustee will also be a beneficiary. Yeah. Yes, sir.
Relating to the long-term care.
Yeah.
What if you have a insurance?
Okay.
Does that wipe out everything you said?
No, it doesn't. So during my misspent youth as a state legislator for 14 years, I sat on the insurance committee. And in the 90s, does anyone remember you couldn't turn TV on without seeing ads for long-term care insurance? And the companies were baffled that we were not breaking the doors down to buy policies. And why do most people not have long-term care insurance? It's very expensive, but I have clients, who willingly bit the bullet and they say, okay, I'm gonna, pay this $5,000 a year so that I'm protected on the other end. But the thing is that your maximum daily benefit I don't know what yours is, and I'm not asking you a personal question. If your maximum daily benefit is 300 a day, I would say you have a pretty darn good policy. But the facilities in our area, we're talking about Ozanam or the Grand and Whitestone. The daily rate is $550 a day. So we're $250 apart. So these people who have the policy and they've been dutifully plunking down their money all along are in my Bayside office applying for Medicaid to cover the difference. You know, so the question became, what the heck did I do this for? I'm definitely not telling anyone who has the policy to get rid of it. I think that's jinxing us. But if you don't have the policy, for whatever reason, don't feel sad that you don't have it, because that daily benefit and the real cost of care, they grow at disproportionate rates. So if I was a big spender and I bought the 5% inflation rider on my daily benefit, the real cost of care is going up 8 to 12% a year. So we're getting further apart as we go forward. For the baby boomers amongst us, I would definitely say that the Medicaid program in New York State, and let me just as an aside tell you that our Medicaid program is the best in the United States. There are lousy facilities out there, and there are better facilities out there. None of us want to be in a facility to begin with, but there's a big variation between facilities out there. The variations have nothing to do with my source of payment, because at the rate of $15,000, $16,000 a month, all of us are going to be on Medicaid at some point. And New York State's Medicaid program pays the skilled nursing facilities a boatload of money. It's not quite $550 a day, but it's not much under $400 a day. They're darn glad to have the Medicaid coverage. So, you know, 90% of the folks in Ozanam long-term care are on the Medicaid program. So get that out of your head, that if, you know, your spouse or a parent needs to be on Medicaid, that it's a different level of care. And this is especially true for home care. That's what most of us prefer, especially women. And in the handouts is an article that I thought was so cleverly titled at the time, Estate Planning and the Single Girl, because most women are going to be on our own. We have an 80% chance of being the surviving spouse. I feel like I have a very good chance of kids being too busy with their own lives, you know, to really be involved in my future care and feeding. So I think it's incumbent upon us to put a little bit of a plan in place. So one of the documents that we should all have, and you don't need me, you don't need a lawyer to do it, it's a living will. And the living will is where we kind of put our subjective wishes down on paper. And the language I have in my living will is, in the event that I require long-term care, I wish for my care to be provided in my home, unless it's not medically possible. So the type of care that we're talking about is custodial care, you know, the cranky functions of daily living, that if we live long enough, most of us will need some help with these things, but it's not medically complex, and I can be in my own lovely home, and we can apply for Medicaid to cover the cost of someone coming in to help me. And if you think, okay, Medicaid home care, maybe they're sending Frankenstein, they're not, because they're afraid of being sued. So there's something called the Consumer Directed Program, where you can pick your own caregiver and New York State will pay that person. So just keep it in the back of your mind that Medicaid home care is terrific. Now, all of that was a lead up to, because New York State's Medicaid program is so amazing. Now, by way of reference, my husband is a geriatric physician. He's the medical director of a facility. And I asked him early on in our dating life, is there really any difference if I'm on Medicaid and you're private pay? Is there a code in the chart? You know, cynical person that I am. No, the care is 100% even, Steven. But because of that, New York State's Medicaid program is what? It has taken over education as a percentage of the New York State budget. So I think the writing is on the wall. They're going to make it harder and harder to get on this program. We see what was a 3-year look back go to 5. It's going to be going to 7. We don't know when. There is currently no look back period for community Medicaid, meaning my house is in the trust, my retirement accounts are invisible by operation of law. My money, if I get sick, the person I've given power of attorney to can throw that into the trust. And today we can apply for me for community Medicaid because there's no look back period. In 2024, that's going to move to 2.5 years. That's still better than the 5 years. So what that means is worst case scenario, if I have a lot of money in the bank and I need care, we put it in the trust and then we privately pay for 2.5 years. And then we can apply for the program. That's as bad as it gets. All right, any questions on all of that? Yes.
Okay, so Medicaid is mostly the lower income, right?
I would not say that. I would say that Medicaid is for someone who requires more care than their $4,000 a month Social Security and pension would cover. That's what I would say.
Okay, so let's say you don't qualify for Medicaid.
Well, who wouldn't qualify for Medicaid? Give me the example of that person.
Let's say you have a retirement that's pretty sufficient and it doesn't.
Okay.
have income.
So if you have a retirement pension and Social Security that pay $15,000 a month, then you can afford to privately pay in a skilled nursing facility. If the income is lower than $15,000 a month, I don't think you can tune out, the Medicaid discussion.
So you would have to purchase long-term care insurance. I would have to, right?
So I'm not getting into your personal situation. If your income is over $15,000 a month, hypothetically, not you, don't shake your head. If your income is over $15,000 a month, then I would say you don't need long-term care insurance and you don't need to focus on the Medicaid planning because you can privately pay for your skilled care needs later on. Anyone who is under that, I think should at least have Medicaid as an option. I'm not, signing anyone up for Medicaid today. I just want you all to sleep a little more comfortably because I think you're all aware that Medicare and the supplement only cover 100 days. And if you don't have a little game plan going before that eventuality, people do not make good decisions, in a crisis setting. And you have adult children who are panic stricken. And do you know how people end up in a nursing home? Given my peculiar job, I can tell you how people end up in a nursing home. No one wakes up one day saying, I want to go to a nursing home. Something happens and we go to the hospital. A cardiac episode, a broken hip, whatever the acute problem is, we go to the hospital. From the time we go to the hospital today, they're trying to discharge us, right? They say quicker and sicker because they get paid not for the number of days I was taking up space at New York Presbyterian Queens. They get paid based on my diagnosis, what I had. So they're looking to get us out on a conveyor belt and we go to rehab. Now, at rehab, we only have 100 days. So the family wants to get mom home. There aren't a whole lot of evil kids who are like trying to lock their parents up in a nursing home, but here's what happens. While mom is in rehab, as the end of the 100 days starts to come, they're getting the heebie-jeebies that mom is still not herself again, and they're worried that if she comes home, even with some home care, that they're going to be getting calls, and they come up with the following plan. And I've heard it in my office a million times. Here's the plan. Well, the 100 days ends, next Tuesday. Let's privately pay for an extra month for her there. Let's privately pay. We'll all chip in the $15,000. At the end of the 4th month, she'll be a little stronger and better, more likely to come home. But you know what happens? The opposite, because that 4th month, they've moved me from rehab to long-term care, where the caregiver to patient ratio is abhorrent. We don't have minimum staffing ratios in New York State. And this is the sad situation where, to kind of go with the flow, people have to become a little passive. And with the, very few number of caregivers, my need to be in a facility after 4 months is greater than it might be after 3 months, believe it or not. Does that make any sense? It's like once I go into long-term care, we have less stimulation and we have more of like a sundowning. I'm not a medical person, but I have to share, the path that I see. So I think it's very important as part of all of this planning to say within this living will that, again, I have them for free on my website, download it, change the language around, make it your own. Within the living will say, I want to be at home unless there's a medical reason that I need to be in a facility. Yes.
For those of us that are planning and game planning, do you have a checklist of things that we would put together from a personal paperwork? So if we did come in to see you, we would have a successful, fruitful, consultation.
Okay. Yeah. So I think, I hope that, everyone takes an action step. My goal today is to give you some very clear information. And a good action step would be do the documents that you don't need a lawyer to do. Everyone should have a healthcare proxy. The form is on my website. I think a lawyer who charges for a healthcare proxy should be shot. I was a co-sponsor of New York State's healthcare proxy law in the mid-90s. And the goal of the law is that it's a DIY, that we could do it ourselves. So I see people out there charging a few $100 for a healthcare proxy, and it makes me crazy. But download the healthcare proxy, download the living will. If you're not a computer person, call my office, we'll send it to you. There's also like a questionnaire, a checklist, things, to focus your thoughts and to bring to the first consultation. Yes. It's you.
I wanted to know, how would you live? What would you do? Or what would you live? How would you live something for a disabled child? How
Oh,
would you protect that so they can get everything?
yeah. So this is one of the areas where we want to customize our estate plan. If we have any beneficiary, a child, a spouse, who has a developmental disability, who has a traumatic brain injury, whatever their situation is, if we think that they will likely be receiving benefits, means-tested government program benefits, I want to leave them their share in a way that does not supplant those benefits. I want what they get from me to add to what the program is going to pay for them. So we do that by way of a special needs trust or a supplemental needs trust. And if the person that I'm providing for in this fashion is a child of mine who's over 18. So now I don't have a legal duty to support them. So I can say I leave 1/3 to Susie in accordance with the provisions of Article 4. And Article 4 is going to build her special needs trust. And it's going to say that her brother is the trustee and he can give her things to add to program benefits. And because I set it up at a time where I had no legal duty to support her, I can say upon Susie's death, her brothers get the assets. So it's not going to be her programs. I'm going to direct it. But that's a good question. Okay, one more and then we'll see if we have any Zoom questions.
The viability of Medicaid going forward, 5 years, 10 years. I just don't see it.
Yeah. So
there for us.
I started to say earlier, before I told you how great the program is, because it's so great, it is so expensive, and the handwriting is on the wall that they're making it harder and harder for us to get this program. So I think that baby boomers amongst us would be well advised. I'm not in love with the traditional long-term care insurance products out there because they're able to raise the premiums. You know, so it's an unfair bargain. If I'm, 69 and I'm saying to myself, let me, lock in a good rate before I hit my next big birthday, there's no such thing as locking in a rate. The insurers can and do have premium increases. The only rule is, and the Department of Financial Services in New York State has to say yay or nay to the request for an increase. And do you know how many times they've said no? Zero. The only rule is they must be uniform in the application of the increase, and they're happy to comply with that. So you're paying for 10 years and you pull out of the poker game when the premiums are eye-popping, you've lost all of those dollars. So there are products out there, and I have no horse in the game. I'm not involved in the products, but I would encourage anyone with an interest to talk to your financial planner, your financial advisor, about a whole life insurance product that has a rider for long-term care benefits. Now, if I'm lucky enough to pass away in my sleep one day in the future without having needed long-term care, great, my kids as the beneficiaries get the life insurance payout. If I do need care, I get to pull from the accumulated cash value of the policy. Okay, one more in the red. Well, I try to put timely information on the website, certainly not although maybe we're doing a recording, if it comes out okay, we'll put the recording on the website. I'm sorry? I was reading that this morning. Okay, so a geriatric care manager is like a social worker who can advise you about assisted living options and it kind of like a broader, more global solution. Can advise my mother on having a contractor come in and make the house handicapped accessible, but a geriatric care manager is not doing legal work. All right, so at this point, let's move to see if we have any questions from Zoom.
Is there a way to put my co-op shares in a revocable trust without notifying the co-op?
Does anyone here have a co-op? Okay, so we'll treat this a little bit quickly. Co-ops, as you know, are not real estate, they're shares of stock. And your co-op board is allowed to implement any crazy rule or regulation they want. They can determine whether or not I have a pet, how many people live in the apartment, whether or not I can sublet it. But there's one thing that they can't do, and that is determine who in my life is going to get the ultimate economic interest of the co-op. So if I leave you my co-op under my will, they don't have to let you live there if you collect rescue cats as a hobby. But when you finally find a buyer that passes muster with the co-op board and you sell the apartment, you're going to get the money, right? After the flip tax. So we use that model. And I worked on the language with the president of the Co-op and Condo Federation of the state. And the language is, we can do an assignment into the trust of the economic interest pertinent to the shares of stock of the co-op. What the heck does that mean? Well, with a trust in place, with the asset protection trust in place, I can legally assign, by way of a document that's date stamped and notarized, I am assigning my future economic interest in the subject apartment into my trust. That is binding on New York State Medicaid. The dollar value is now all in the trust. So for those of you who are in a co-op that does not allow trust ownership, they can't prevent you from doing this limited assignment of the financial interest. And even if your co-op does allow trust ownership, a lot of those folks opt for the limited assignment because it's a simpler mechanism.
Is a TIAA retirement account invisible to long-term care facilities?
Yes, a TIAA CREF account is totally invisible.
And what if the settler of the trust becomes disabled and not able to sign along with the trustee and selling of a property with a trust?
That's an excellent question. So we said if I want to sell the house, we need my signature plus my trustee's signature. If he turns out to be a flake, we said that we can remove and replace him. But if I am unable to give that needed signature, who can sign for me? Our attorney. Yeah.
And does my trustee have to file an income tax return on my asset protection trust if there's no income generated?
Okay, that's a really good question. What is the income tax treatment of this trust? So if I end up putting CDs or a brokerage account in the trust later on, and it's generating dividends and interest income, where does that income get picked up? Most of us make the election that the income gets picked up at the human being level. So this is grantor trust status. So the asset protection trust does not help us with income taxes, but it does not hurt us with income taxes either. It's neutral. But with one exception, if I put investment property in there and it's generating income and the income is coming to me, and in the future, I need to be in a nursing facility, we want to have the ability to go in that trust and shut off the income valve later on if I don't want all of that income appearing on my Medicaid application. So we can change the income tax election later if it's going to help us.
Okay, and if you move out of state, you need to make a new trust, and is it possible to make changes in general?
Okay, so there are documents that if we move to another state, we want to update the healthcare proxy. We want the medical staff in the hospital to see the document that they're used to seeing. We want to update the power of attorney so that the 24-year-old at the bank sees the form that she's used to seeing. Your big documents, however, your asset protection trust, your will, they do not have to be changed if you move out of state. The trust is a creature of the Internal Revenue Code. So it's applicable in all 50 states. So my initial asset protection trust owns my New York properties. We may sell them and now it's going to have money. And I use that money to buy my new place in South Carolina.
There's a follow-up question to that. Can you use your own all-purpose power of attorney for banking within your own state, or do you need to use the bank's power of attorney?
Okay, so banks are increasingly difficult to deal with. And when you go in there with a power of attorney for your mother, don't expect them to let you transact business in the next 2 days. They have to have their legal department look at it. So we did legislation starting in 2009 that was designed to prevent this problem. And it says that a third party, this is a bank, a third party has liability for failing to honor a power of attorney that's valid on its face. They don't seem to care about this language. And in reality, who has money to then go, pay some lawyer 5 figures to start a lawsuit against Chase? So the practical advice is when you do your broad, durable power of attorney, would it be a bad idea to also ask the banks that you do business with, do you have your own form? Okay, can't hurt. Bring those forms to the office on the day that we're signing the big power of attorney, and we'll sign the little powers of attorney so that your agent has an easy time at your particular bank. Yes.
What happens afterwards? So you made the trust and then you died. What is the procedure afterwards? Do you go to the trust attorney? And what are the costs involved in your?
That is really, really an excellent question. How do we wind this up? In a situation where all 3 beneficiaries get along, or they can pull it together to sort of get along during that wind up period, and they're all getting a third, your trustees, if you have 2 trustees or 1 trustee, I really try to talk people out of having 3 trustees. It's a nightmare. Your trustee needs to be discharged from liability. And that's as simple as a form saying, I, Roger, agree that in exchange for my 1/3 share of the trust, I absolve Kathy from all future possible liability. And even more important, I promise that if a creditor appears that we didn't know about at the time of distribution, that I promise to cough up my 1/3 share. Otherwise, it would all be on the trustee. So the trust, it's a very clean, simple wind up. If we have 2 trustees, 2 beneficiaries, and they love each other, and I get a call that mom passed, what do we need to do? You don't need to do anything. If your plan is to sell the property, then your last act as the trustees will be to sell to the new people. The new people make the check payable to the trust. We go to a bank on the day of the closing to establish an account in the name of the trust till the check clears. We split it, and we didn't need an attorney. If the trust has to continue because my son predeceased me and now his 1/3 share is being held for the benefit of his 2 kids till they're, let's say, 25, and I have my daughter, their aunt, doling it out to them before that age, then the trust stays open longer. So
What are the costs involved?
it depends on what you need.
Are there summary judgments that have to be done?
No.
I've been hearing like summary of the estate. and
Oh, no.
summary-
That's if you have a disgruntled beneficiary. And this is a good little side topic. What do we do if one child needs more than the others? Well, it's nice whenever we can to name the beneficiaries even Steven within the document. I don't care if my son is a neurosurgeon and he tells me, please don't put me in the estate, give it all to my sister. She's had a string of bad luck. At the point of a parent's death, people are out of their minds with grief. And I don't want the last words that my child reads from me that he got 20% and Kathy got 80%. But if we need to give Kathy more, maybe we make her the beneficiary of a CD at the bank. Okay, so now she's getting more, but the document says mommy loved everyone equally. So in a smooth situation, there are not costs.
Really?
Yeah, yes.
Somebody said, can't we word probate just by adding someone to the deed?
Okay, so remember, can we avoid probate by throwing another name on the deed with me? Remember what I said, if we take the house and transfer it to the 3 kids, all of those bad problems, they got the carryover basis for capital gains and it's subject to their divorce claims. If I put my son on the deed with me, now on my half, we have all of the liabilities and vulnerabilities of the nursing home. And on his half, we could lose it in a divorce and he has a capital gains problem on his half. So I think joint ownership of real estate is the worst of both worlds. Yeah, anything else?
What should people with pets do in regards to their estate planning?
Okay, this is a big topic. Who here has a pet? No, really, more people must have a pet. Okay, well, we have a representative sampling here because more than 70% of Americans have pets. And I know it's considered a little flaky to deal with them in a legal manner, but I do recommend that folks do it in the realm of a prenuptial agreement. You might want to spell out who gets the pets in the event of a split. Within the estate plan, I have a lot of senior clients who would love to have the companionship of an animal, but they feel it's irresponsible, given the statistical likelihood that the animal will outlive them. With a little good planning, we don't have to worry about that because I can name someone who can make arrangements for the pet. It doesn't mean that they have to necessarily take the pet into their home, but they are in charge of coming up with a good plan. I might want to make an arrangement with like an animal rescue foundation to say that they get X amount of money for finding my pet a good home. So I just think it's a nice thing to do and not leave your beneficiaries in a quandary about what to do with a pet. Yes, all the way in the back. I'm not hearing you perfectly. You mean a hypothetical person owns a house with their boyfriend? Okay, so the house is jointly owned. Okay, is it joint? That's not my question. My question is it joint tenants with rights of survivorship? You look at the deed. If it's tenants in common, now you need to talk to this person about doing an asset protection trust for their half of. Yeah, the way to prevent Medicaid from getting it is to do an asset protection trust. Yeah. It's a hybrid. It's in the middle. Yeah. All right. Do we have any other Zoom questions? Okay, yeah.
Nobody wants to put up housing trust. Is there any limit of house prices?
Okay. So is there any limit on, I'm going to recast the question to make it broader in applicability. Is there any dollar limit as to what I can load this trust up with? So if we put assets in the trust under current New York state law, and when we add them all up, if it's under 6.8 million, the beneficiaries don't have a problem. If I have a $12 million multi-unit in Ridgewood and it's owned by an LLC, then I want to do a different type of planning for anything that's over 6.8 million. So with the asset protection trust, it can own assets valued of up to 6.8 million. Okay, any more Zoom?
Yes. Right, is the difference between a living trust and a revocable trust.
Okay, what's the difference between a living trust and a revocable trust? I hope one of the takeaways from today is maybe to demystify all of the trust language, because a lot of it is repetitive. A living trust is any trust I do while I'm alive. Unlike a trust that I build into a will that only takes effect at my death. That's a testamentary trust. But I can do a living trust that's revocable. I can do a living trust that's irrevocable if I was stupid, or I could do an asset protection trust that's a living trust. Anything I do during my life is a living trust. Yeah.
And how are capital gains, not income and dividends, handled in the final settlement of the irrevocable trust?
So the reason for that?
No, how are capital gains?
Okay, so there are no capital gains taxes on assets going from the asset protection trust to the beneficiaries. We totally eliminate capital gains.
And we're getting a lot of questions in regards to like the cost of making changes in the trust and moving.
Okay, so the purpose of today is really just pure education. If you have a specific question and you want to talk to me one-on-one, you would call the office and we would have a chat about anything that you want. Yes.
Question on the Medicaid look back. Suppose you did a deed transfer. This is my mother. My sister lives with my mother. She's 96 years old. And they haven't done anything yet. From what I understand, if she did a deed transfer to my sister, who still lives at home and takes care of my 96-year-old mother, is that exempt from the 5-year look back?
Okay, so one of the imperfect emergency planning techniques is called transfer to a caregiver child. Now, remember I told you all of the rotten things about turning the house over to someone else. Well, we're less concerned about all of those rotten things if the alternative was to have a Medicaid lien put on the house. So is it better to do the trust and have the 5 years under your belt? 100%. If you're allergic to planning and we're in the situation where the 100 days of Medicare and the supplement are going to be up tomorrow and we need to put in a Medicaid application, then one of the things we look at is a transfer to someone who can be considered a caregiver child. They've lived there for 2 years prior to the nursing home admission. The problem still is that there's going to be a carryover basis for capital gains, number one, and number two, if that child who receives the house has a little whisper agreement with the siblings, I'm going to share it with you later. Medicaid doesn't like that, and they look at that and they say it was a fraudulent caregiver child transfer, number one. Number two, even if the person who received the house splits it with their siblings after mom dies, now you have gift taxes to deal with. You're only allowed to gift $17,000 per person per year without having to do a gift tax return. So is it an emergency planning option? Yes. Is it a good planning option? No. Any more on Zoom?
Yes. Any tips for second marriages?
Second marriages. This is huge because even for happily married folks, a long-standing, happy or sort of happy relationship that you say is not ending in a divorce, the marriage will end, right? And in my own life, I live with someone, my spouse needs to be married. It boggles my mind, the questions I get, such as, where are the light bulbs? Well, we've lived here for 15 years. Is this for real? You don't know where the light bulbs are? This is true. So I say to myself, he would be remarried. If I die before him, he will literally be remarried in like 6 weeks. So now I'm already plotting against that person. And do you remember in the asset protection trust, when I said that we have the 3 beneficiaries, but we can make changes? We want to be able to make changes to protect against their divorces, on and on and on. But I put special language in there, and I say we can make changes to the beneficiaries between and amongst our lineal descendants and trusts for their benefit. Who does not fit that description? His new special friend does not fit that description. So if you do a trust, you're really, really protecting your kids and your grandkids from some person coming around, and that could be trying to trick someone out of the deed to the house. It could be someone, pretending that my then elderly husband looks like, I don't know, Burt Reynolds or something. And he is kind of thinking about giving her something. A good plan will protect against that. But in a second marriage situation, we need to deal with who's going to be living in the house. Now, let's say I'm the surviving spouse, and my new, younger, handsome husband is saying to me, you really should, add my name to the deed, because what's going to happen to me, when you die, I'm going to be on the sidewalk. And he says to me, I'll take care of your kids. Well, he will not take care of my kids. I see this all the time in my office. And then we have my kids saying to me, don't let his name go on anything. We're not going to kick him out. We'll give him a place to live. We can't believe that either. So the compromise here was always an imperfect compromise, where we said, I give Fabio lifetime ownership rights to the house. That's not good, because he could be alive, but in a nursing home. He could be alive and he moved his new special friend in the house. And now my kids can't enter to get their baby pictures because he has lifetime ownership rights. He could move to Florida and rent it out. He's getting the rental income. So don't give the new spouse a life interest or a life estate in the house. Give them instead the right to occupy the property until the earlier of their death, their voluntary departure, their stay in a nursing facility of 4 months or more, or I could be a micromanager and say, or his cohabitation with an unrelated person. If I say he has a new situation, let them go live at her house and my kids can then sell the house. So this is an example of something we need to think about. What if I have one child living in the house and I want to split everything 3 ways? Well, make sure that there's not going to be, a blood feud between the kids, and say she has, let's say, 24 months to make a decision as to whether she wants to buy the other 2 out, or just give her a soft landing to make new arrangements. Does that make sense? Yeah.
We have a question here regarding capital concept. Rather than do a promissory note in the 11th hour on the nursing home doorstep, create an annuity, annuitize it, and if there's no likely needs to be designated a beneficiary of the annuity, Medicaid will only be able to recover up to the amount that Medicaid had expanded on the patient. Remainder of the trust fund will go back
Okay,
to
this
the
is, okay, you'll be happy to know that I'm not going to give the 40-minute answer that question requires. But it's simply at the 11th hour. If I've done nothing and I have no caregiver child to do an emergency transfer to, we are looking at losing approximately half of the assets. And the question is, instead of losing half of the assets, buy a big annuity and turn it into a little stream of income. And now all Medicaid would only get the little stream of income. In 2006, when they changed the look back from 3 to 5, they also clamped down on that planning technique. And they say, yeah, you can do an annuity, but they have to be very big buffalo-sized payments, and we get those big payments. So you can't do the little trickling payments anymore as an 11th hour planning technique. Before going to any final questions, I do want to add to what John Golden was talking about earlier. And, it's not always the topic that we want to talk about, pre-planning our funeral arrangements. But I have a kind of bizarre perspective. I have a bizarre career dealing with grief-stricken people every day, every week. And I have learned a little bit through the families that I work with about the importance of pre-planning. And who here amongst us has had to make funeral arrangements while you're grief-stricken? Okay, I've done it. He's been there with the Kleenex. I was literally out of my mind with grief, and buried my grandmother with my wedding crown. I was just so grief-stricken. We're not making good decisions while we're grief-stricken at that point in time. And for those folks who do the pre-plan, I sit with them in my office, and do you know what they say? They say that this is what mom did, so I wouldn't have to go through it at that point. And it really is, and in my book, Love and Money, I talk about the wonderful gift that it is to do any form of a pre-plan. As John said, even if it's just, making some advanced selections so that grief-stricken people aren't, ordering a horse-drawn carriage or, I don't know the things I would have done if I had $5 back at that time, but it probably wouldn't have been prudent decisions. So I do encourage you to do that. And what all of this stuff is, it's planning for our own future security. What can the me of today do for the me of 20 years from now, who might not, be totally with it, what can I put in place? And I come back to encouraging you to create a file folder where you have your social media passwords, where you keep, your planning documents, where you keep the most recent statement to all of your financial accounts, where I hope if you came in this morning without a healthcare proxy, that you download that document, you fill out your healthcare proxy, and you're going to feel, I think, a little bit lighter. You're going to feel a little virtuous that you're, taking the bull by the horns. You got some information, and you're putting a plan in place for your security first and foremost, but also ensuring that the kids are not left with a mess, tangled up with taxes and in court for a year with a probate. You want things to pass smoothly and cleanly, and it really is a great gift for the next generation. Yes.
Quick question, you mentioned about gifting for 17,000. Do you recognize that? Like if you have a lot of money, do you recommend doing that? Like
You're going to have a whole lot of new friends today. Yeah, you know what? It's a personal situation. There's a saying, you want to give with a warm hand. You want to see people enjoy it. But a lot of people are real estate wealthy, and they don't necessarily have a lot of disposable cash to be able to make these gifts. So I think it's a personal decision. Certainly, if the estate, when you add up everything, including life insurance, death benefits, retirement account death benefits, if you're poking above 6.8, then that person, I would recommend you want to shave it down by making $17,000 gifts.
And what are the tax implications of that?
There are no tax implications. So we can make a gift of up to $17,000 per person per year, free of transfer tax to the grantor, and the recipient of a gift or the recipient of an inheritance never pays a tax.
Thank you.
Okay. Any final? Yeah.
I have a friend who has a timeshare. What does that fit into?
That's not even an asset. That's a headache. For most people, no. Some people they know how to use them. I have a friend, he knows how to trade them, and most people that I know want to really get it sold before they die, so the kids don't have that headache. Yes.
Say you haven't you're not going to putting this in an estate.
Yeah.
And I die and the house goes to my children.
Right.
Do they pay a capital gains tax?
If it goes through the will, they don't pay a capital gains tax, but they do have to go to probate, and
They go to probate.
they have to go to probate, and that's about 8 months. And then the question is, who's paying the utilities, the taxes for that 8-month period before they're able to do
It
anything?
is like 8 months.
Yeah, yes.
You have to update your state.
That's a really good question. How often do you update your documents? If the will I did in 1988 names the people that I still like today, and the will was validly drafted, you don't have to update that. If the daughter got divorced and remarried and divorced and remarried, and we've had 4 different names, that doesn't mean you have to update the will, as long as we can identify the person. Can you do your own will? Well, on a game show, the correct answer would be yes. In law school, we learned that you can write your will on a kitchen cabinet. That was a case that I studied in law school. But the family is simply going to be in court for years. Look at Aretha Franklin. The estate opened for more than 5 years. She was a brilliant person, but thought she could, make some notes, and they found several different iterations of her wishes in couch cushions. I would not recommend it. There are many things you can and should do on your own. As John mentioned earlier, appointment of agent, and this is such a gruesome sounding form. And I was in the legislature at the time, but I take no blame for the name of the form. It's called appointment of agent to dispose of remains. You don't need a lawyer to do that. I have it on my website. I'm sure you have the forms in your offices. Do that form so that kids aren't fighting. And this is important if we have a child who has different religious or philosophical ideas than the other kids. You want to just be crystal clear to the extent that you can about what you want and who is in charge. Any final little question?
All requiring termination of the trust after a person passed control or I would always some trusts have instructions to say that trust is to be terminated now, but what's your recommendation for terminating a trust?
Well, again, terminating a trust, it depends on the language in the trust. So I think of a trust as the inside of a board game, right? All of the rules are in there, and it differs from one to the other, with a board game or with a trust. And the trust is going to say, if my kids are all, even Steven, they get along pretty well, no one has special needs. What if I have a son, he has no real diagnosis, but he's not firing on all cylinders. He's 57 and lives on my couch watching TV all day. Do I think he's going to be able to really handle 1/3 of the estate? Probably not. And this is not, a time when we're meeting with the estate planner. We're not doing that son any favors by saying, yeah, he's A-okay. He just, hasn't found the right job yet. And every job he's had, they're all out to get him. Whatever his situation is, if I'm honest with myself, I think he's going to need a little structure. And maybe his 1/3 gets paid to him 5% a year for 20 years. If I know he hasn't saved $5 toward his own retirement. So that would be an example of a trust that's going to stay open for 20 years after my death. Most trusts are designed, like the Mission Impossible tapes, to self-destruct upon the occurrence of my death. Yeah.
I'm sorry, back to the question of the deed transfer with 90-year-old mother and give her a child. What's your question?
Question is, if the child decides to pay you off this
After
Then there are gift taxes, and the child still has capital gains upon sale. I would not do that. Yeah. Anything else?
I'm sorry, was the capital gain like in the millions? Was the value of the home?
So capital gain combined state and federal with the 3% Medicare surcharge, you're looking at about 23%. Yeah, it's no joke. We've spent too much on that topic. Any other final question on anything else?
We have questions regarding estate planning as a single person who's not married, doesn't have any kids.
So I think we should all view estate planning as if we were a single person, because the overwhelming majority of us will be single one day. And I don't think it's a good idea, just because, I was a caregiver for my ancestors, to think that my kids are going to be able to do that for me through no fault of their own. They're working 2 jobs. They are dealing with kids playing sports and running around. I need to be a little self-sufficient. And what that means is putting my ducks in a row, getting my information put together. As years go on, we want to share with each other information about a hairstylist that makes house calls. We want to start putting this information together. And maybe that's assembling a team. You have your accountant, you have your financial advisor, you have your estate planning attorney, and in an ideal world, you could do a Zoom call with these folks once a year and everyone's on the same page. So I think when we do that, they say fear of aging is our second biggest fear, that we're more afraid of aging than we are of death. And I think we take some of the teeth out of it by doing everything we can to make sure that our legal affairs are in order, that we're protected from con artists, that our kids are saved from taxes later. I think it's as important as eating right and exercising. And when we're, planning for all of these different areas of our lives, I do feel that we're a little happier. It's one fewer thing, eating away at the back of my brain. Oh, I need to deal with that. And if I want to leave you with one thought, don't let the perfect be the enemy of the good. If you put something together that's 85% good, and you didn't, perfectly have this nuance figured out, all you need to do is make sure that you retained the right to make amendments to it in time to come, so that future get-togethers were shaping something that you largely have put in place. All right, last question all the way in the back.
What do you think was the best advice that Dr. Phil gave you?
The best advice that Dr. Phil gave me, well, he was a very lovely guy to me, and he wrote the foreword to my book, and yeah. So, I don't. I was running late this morning when I had that nightmare about oversleeping, and I thought, let me bring a book and we're going to raffle it off or something. I apologize. The books are available on Barnes & Noble, on Amazon, and for a limited time only. If you did buy a book, you can use the purchase price as a credit toward any legal work that's done. But I do think I put a lot of good info in. Now, I said that was the last question, but there's a lady who did get up at the same time as the gentleman. So what is your question? Okay, so this goes back to, you have 3 beneficiaries and one or more of them need a roof over their head and the other one doesn't. You need to put language in place, because one is going to want to cash out and the other two, by definition, they're not in a position to buy them out. Otherwise, they'd have their own houses, right? Someone living with me when I'm 97, they have a reason to need to live with me. So I need to put language in there, and I need to say that Mary and Susie can stay in the house as long as they need to, provided they pay for the upkeep and maintenance. And if Fred wants to cash out, they can pay him his third in a promissory note. So they're probably not going to qualify for a conventional mortgage, but this is an example of how we can put language in there to keep everyone in their own lane and not killing each other. That was a good last question. I know that some people are shy to bring up personal things in a group setting. I'm always available via email if there was some little question, if you want more clarification on the caregiver child transfer and why I hate it so passionately. Please feel free to send me an email. And again, for the folks who are with us on Zoom, give the office a call Monday if you want us to send you a packet. So with that, I want to thank all of you for coming out in the crummy weather, and Gleason's for hosting us. Thank you.